Okay, what is your name, sir?
Theory Johnson.
In 23 CR 2259, there's a motion for a bond reduction in your case. Go ahead. It's your motion.
If you could swear in, Judge.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand, Mr. Burbank, as his attorney. Go forward.
Yes,
Thank
please, the
you.
court.
Yeah.
For the record, what's your name?
Theory Johnson.
Mr. Johnson, you're currently charged with the offense of murder, is that correct?
Yes, sir.
And we're here asking that your bond be reduced from $250,000.
It is how much now?
It is $250,000.
It is 200, $250,000 right now.
And prior to this incident, where were you working?
TDCJ.
And how long had you worked there?
Year 2 months, 3 months roughly.
Where were you born and raised?
Well,
Texas.
So-
hold on. You were working there. What were you doing there?
Correction officer.
He was a correction officer.
Okay, that's what I thought. Okay.
TDC. And so you've lived all your life in Boulder.
Yes, sir.
And you have family in Boulder?
Yes, sir.
And who do you have in Boulder?
Mother, my father, and several relatives.
Do you have brothers and sisters?
Yes, sir.
Okay, and they live there all your life?
Yes, sir.
You have tried to post a $250,000 bond, correct?
Sir.
At this time, you have sufficient assets in order to post the bond. So you've asked your parents or your family to ask around and they have that's sufficient. If they're requested, correct?
Yes, sir.
And that's in excess of 25, 30.
Yes, sir.
Do you have any real property or any retirements or anything that you can cash in or sell and what get any funds?
Yes, sir.
In fact, you don't even have a vehicle.
Yes, sir.
Are you asking, so you have no assets at all to post? You asking this court to reduce the bond to a reasonable amount so that you may post it pending.
Yes, sir.
When you abide by all the rules and regulations, what may impose, for instance, it may be staying at a parent's house or of course, definitely within the jurisdiction of this court or this area, and other type of regulations to be able to correct
Yes, sir.
and pass it in the street.
Spain, any questions of the defendant?
You never denied being in the shooting, right?
Yes, sir.
Matter of fact, you were shooting at an individual that was stealing your car. Is that correct?
Yes, sir.
And then after the car wrecked, you went back inside your apartment and got a shotgun and came back out while the person was inside the car and shooting, right?
I'm gonna have to ask him not to, under oath to say anything. There's a probable cause application there.
All right. I'm waiting for it.
Oh.
If she's getting it. I don't have it. It's not in the file. Yeah. It wasn't filed.
So you're gonna advise him to take the fifth on the rest of this? You're not gonna let him testify the rest of this?
Well, we're going to trial.
Huh?
No, we're just talking about the hearing right now.
Yes, sir, just for this.
Do you want to ask any other questions or?
No, sir, if he's not gonna let him answer any more questions on that part.
All right, let's talk about the rules for setting bail. this is found under Article 17.15 of the Texas Code of Criminal Procedure. The nature of the offense and the circumstances under which the offense are committed are to be considered, including whether the offense is an offense involving violence as defined by Article 17.03. The defendant has been indicted with the offense of murder, alleged to have occurred on or about July 30th, 2023. It is alleged shooting the victim with a firearm. And so, this is a first-degree felony, which is a most serious offense, and this felony is also a crime of violence. Then what these multiple pages involve are not arrest warrant affidavits. These are search warrant affidavits. Which, though, include information concerning the alleged offense. All right, essentially, this affidavit for search warrant seems to state that on July 30th, about a year ago, this happened last year, Beaumont police respond to 6550 Phelan Boulevard in Beaumont in reference to a shooting and a deceased body of Xavier Massey was discovered in the driver's seat of a white 2017 Nissan Pathfinder. That was your vehicle?
Yes, sir.
Yeah. And Massey had succumbed to multiple gunshot wounds according to this affidavit. And the vehicle showed extensive front-end damage plus multiple bullet impacts along the driver's side of the vehicle. Officers found a trail of 9mm shell casings tracing back to a parking spot in front of a particular apartment at that location. The vehicle was registered to the defendant who resided there. And according to this affidavit, a witness or witnesses stated that they perceived that someone was attempting to steal the defendant's vehicle. And this is, looks like 10 o'clock in the morning. The defendant ran after the vehicle, yelled at the driver to stop. It did not. And the defendant started shooting at the car with a pistol he had. The car was wrecked. The defendant went back inside the apartment and retrieved a shotgun, approached the car, and began shooting at it with the shotgun. the defendant was interviewed. He declined to answer any questions without an attorney present. However, he volunteered one statement that he stated he was getting ready for work and someone was stealing his vehicle. Okay, so there are the details from the affidavit for a search warrant that was granted by a district judge concerning the facts of this case. Okay, so the nature of the offense and the circumstances under which the offense are committed are to be considered. And again, this offense, which was alleged to be murder, in that it alleges by the grand jury that the defendant intentionally and knowingly caused the death of another with the use of a firearm. So it is an offense involving violence, a most serious offense, murder. So that is an aggravated factor in determining bond. Then the future safety of a victim of the alleged offense and law enforcement community shall be considered. Well, I don't think that's an issue here because the victim in this case, or the complainant, is deceased. Now, I don't, you've presented, there are other attributes, and the defense has presented a succinct set of information for the court, but under court decisions, there are several other aspects which the court doesn't know anything about. It's ignorant to, and that's not my issue to address. I don't know anything about that. All I know really is statutorily that this involves a most serious offense of involving violence, and some information concerning the background of the case. But other issues that the court can consider, it's not before the court. Nobody's submitted them, so I'm kind of in the dark on that. So what information I have is,
What do you?
I can't do that. Those are
I mean, Judge, we
factors
have-
of bond that's for y'all to present, not me to pull out.
We have that he's a lifelong resident. He worked for TDCJ. He has family members.
Whoa, hey, sit down. I ain't sit down.
And you
No.
can sit
Hey,
down.
look, Bob,
Sir,
whatever they do with your bitch ass, I'll be
Sir.
working on your punk ass, you motherfucking bitch.
he is arrested.
17-year-old little child, motherfucker.
He is under arrest.
Bitch.
He is directed to be arrested. He is directed to be arrested.
Want to do that anyway, fuck faggot.
There shall be no outbursts allowed. There shall be no threatening of individual. That is a constitutional right violation. The peace and order of this court has been disobeyed, and that person is taken under arrest immediately.
Phone is on the floor.
No.
So now you gonna fuck over my phone.
Okay, who was that person? Does anybody know who he's what?
The father of the deceased.
The father deceased, okay. Well, too many cases in this court involve issues where family members are under stress and distress for losing a family member. We all understand that. Nonetheless, we try to deliberately move through proceedings in accordance with law, because the law is set to determine an outcome that is as just as it can be and as civilized as it can be. And outbursts like that have no place in getting to a managed completion of hearings or resolvements in matters which need to be deliberately and intelligently and based upon law accomplished. And this isn't a time for a lynching. And that's no place in this room for that sort of behavior. So now he's arrested. But we're going to get back to this hearing on determining what is appropriate here. And the court's obviously not going to consider. Well, we got, we're listening to that person. You can hear the person who's still complaining about him being arrested for his actions, and obviously his decision to act outside the bounds of the law don't do anything to accomplish legal methods of deciding important issues.
I believe his criminal history is very limited.
What is it, if anything? Do we know?
Well, he works at PDCJ, so we know he passed background. He does have family ties, has lived here in Beaumont all his life. Has family here, substantial family. He's lost everything in reference to being incarcerated, in reference to financially. The car at the time was just purchased, and was anything. I don't think he has anything.
I don't show him criminal history, Judge.
I haven't criminal history. He was on payments, so he's lost that.
What are you asking for?
I'm asking for $100,000, Judge.
All right, state your response, please.
Judge, even though these are strange circumstances, the fact that he went back out after the crash occurred and shot this person while they were sitting in a car with a shotgun, I got a problem with that. I think the bond is sufficient the way it is. Or with the,
Sir,
with another
if you
guy.
want to, if you want to talk to him, you need to talk to him discreetly. But if you want to make statements that I can hear, I'm going to take those into account. And this, once again, you're beginning to act like someone who makes outbursts like that. There are rules of decorum. If you want to take the stand under oath, you're entitled to. If you want to talk to him, you're entitled to. But if you speak to your attorney, it needs to be discreetly, not in a way that all of us can hear, because that's not discreet. That's no longer something that's protected under confidentiality rules when we can all hear what you're saying. Well, I don't know a lot about the defendant except his work record. But it begins here with, under the statute, the nature of the offense and the circumstances under which it are committed are to be considered. And right now we're talking about a crime that is involving an article of property, which is generally the second most expensive thing people have next to their home. So it has importance to people. And not only we just don't get around on horses anymore, but it's mobility, which is required to get to and from work and to and from food, to and from hospital care. So it has its importance. But what I'm reading here is a situation where when somebody is fleeing in the car um, the question becomes, what can you do? And lethal force is not the answer when it's involving the theft of property.
I think that comes out during trial, Judge.
I think it will. I'm sure it will,
Yeah.
but right now, the goal is, of course, to get the property. So the property was disabled, right? Here at the scene.
Yes, sir.
And that's the problem, is what the state has addressed, is I think the defense can do what they need to do to try to stop the theft from occurring. But once the theft has occurred, or once the piece of property is disabled, going back to get the shotgun and killing the guy was then an execution, which is not an option under law for the theft of property. It is not, that is not an option of punishment under the law.
Again, Judge, I think those are
Is
issues.
execution.
Right, I think that's what the court assumes, and I think it's an issue at the time
Well,
of
no,
trial.
that's what happened though.
Well,
The car was disabled. He goes and gets a shotgun and then kills the person.
not necessarily, Judge. I can't,
Well, the person is dead, isn't the person deceased?
Yes, sir.
Was the person killed by the shotgun blast?
There's several bullet wounds to this individual from the back, the head and side. And I'm trying, it's not my case, but there were 2 shotgun shells out
Was
there.
anybody else
at the-
shooting at the person
No,
other than this
No,
defendant?
sir, but there were 18 shots fired from the 9mm, and then there was 2
Okay.
shotgun shells out there at the end.
Okay. I think people have a right to try to stop the vehicle and
Under certain circumstances.
under
yes,
circumstances,
Yes, sir.
but
a deadly
once the
weapon.
vehicle here, the court's finding is that the vehicle was disabled. And then after that is where the problem exists on his bond.
well,
I know you
Respectfully
disagree with that,
disagree
but that's
with
what
that
my
fact.
finding is what happens with the shotgun and the lethal force that was used after the car was disabled is contrary to what the law allows. And just like that man being arrested for his outbursts, which was against the law, this court is going to find that the way the defendant handled this, especially after he goes to get the shotgun when the car is disabled, is an aggravating factor that weighs against a bond reduction under this case. I find the bond to be reasonable, and that here he goes and executes the person after the property had been disabled, and that's a different, put this into a different situation. I can appreciate him trying to stop the loss of something expensive like that, but it's what happened after the car was disabled. He was not getting his property back after that. He was taking revenge. And that does not weigh for his benefit. And I find that bond amounts are appropriate under these circumstances. Okay. What's the next event
we're set September 16th.
for?
Trial.
Trial.
Okay, done. Thank you.
Excuse me.
Yes, sir.
So,
Here's this